Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina, and today's topic, does the FRAND framework need a fix? A conversation with Professor Jorge Contreras about antitrust and IP. In last week's episode of Our Curious Amalgam, we provided an overdue introduction to FRAND, or Fair, Reasonable, and Non-Discriminatory Licensing and Litigation. In this episode, we dive even deeper to better understand some of the ongoing debates and critiques of FRAND and potential reforms. Joining me today is my co-host, Anora Wang. Hi, Anora.
Hi, Christina.
So what are we talking about today, and why is it important?
Okay, now we're going to the deep sea. We have charted some waters that's uncharted before. We talked about FRAND, we talked about practice here in U.S. and somewhere else, and then now it's time to do some critical thinking and maybe address some fundamental issues with the framework. So it's important that we do that with a scholar that's known for that.
And who is that scholar that we have with us today?
Our guest, Professor Jorge Contreras, is a professor at S.J. Quinney College of Law, University of Utah, and a recognized expert on antitrust and IP. Professor Contreras teaches courses on intellectual property and property law and has previously taught in American University Washington College of Law and Washington University in St. Louis. Before entering the academy, Professor Contreras was a partner at an international law firm, Wilmer Cotley Pickering Hale and Dorr, that's a lot of names there, where he practiced the transactional and intellectual property law in Boston, London, and Washington, D.C. Professor Contreras focuses his scholarship on the development of technical standards and the use of dissemination of data generated by the large-scale scientific research projects. He has recently testified in front of Congress about relevant issues. So Professor Contreras also serves in leadership roles in many organizations, and that's how we know him. He's a co-chair of the interdisciplinary division of the ABA section of Science and Technology Law and a member of the advisory board of the American Antitrust Institute. So that's a lot in the intro, but we know
I think we have the right scholar.
We have, yep, exactly right.
So Professor Contreras, welcome to the program.
Thanks. It's great to be here.
Professor Contreras or Jorge or George, I would stick with Professor. So we hope to structure our conversation very complex and very critical in 4 buckets. I know you take a lot of issue with the first bucket, but let's go there. So commonly, people know that FRAND issues, it can be controversial, and people try to be, when they're generally talking about that, try to be simplifying things. They would refer to a certain group of people as in the camp of innovators and the other as in the camp of implementers. And you take issue with the economy, with the dichotomy. But why don't we explain what's the dichotomy and why that does not make sense to you?
Right. So this is really a question of terminology, right? Not the fact that there's a divide in the standardization world, because there clearly is. But standardization has been going on for well over a century, about a century and a half in the form in which we know it. And there have always been divides and controversies among the people involved in it. Those divides have been between producers and users of standards, between consumers and corporations. It's only been in the last couple of decades, though, that we've experienced this new divide, which is a divide between patent holding companies and companies that make products. And the problem with terming this divide innovator versus implementer is because it's a highly loaded terminology, and deliberately so, right? Mm-hmm. When you call one group the innovators, right, that automatically makes you think things that are good. You associate them with Thomas Edison and lots of, very positive things. The Constitution, which is designed to create incentives for innovators. But the truth is, in this world, the product manufacturers that use these standards are also innovators. And in fact, companies that make products like Apple and Intel and Samsung and Huawei, they're incredibly innovative companies,
Mm-hmm.
even though in this debate, they generally fall onto the side of manufacturers of products rather than companies whose primary goal is to monetize patents.
Mm-hmm.
And so in my writing, I generally refer to these two camps as product-centric firms and patent-centric firms, because that's really what the debate that we're focusing on is about.
Right. So your proposed alternative terminology, product-centric versus patent-centric, that's not so much about who is owning certain patents, implementing certain patents, but what essentially the company is driven to do, right? Some assert patent rights, but don't really reduce them to practice and actually make new products. And that's a group that, at least to some, is the most concerning. Is that right?
Yeah, that's exactly right. I mean, I think one problem that we have in this debate about standards these days is that most people who are involved in this debate haven't been doing this that long, and they don't have a great perspective on the overall industry. But if you look around, like the vast majority of standards efforts and standards, thousands of them going on around the world, there are no patent disputes. Some of the companies who produce these standards in SDOs around the world, they have lots of patents, but that's not the primary goal of standardization. The goal of standardization in most contexts is to create standards so that products are interoperable, because the goal of all of these other companies is to make and sell products and services that take advantage of these standards. We've experienced kind of a weird footnote in history with wireless standards, wireless telecom and wireless LAN standards, where there's this incredible emphasis by some companies on monetizing patents. And so in most of the standards organizations in the world, and most standards in the world, there are no royalties charged on patents. You buy a product, it's standardized, you probably paid the manufacturer of the component that went into that product that embodies the standard, and that's it. There aren't these royalties being charged elsewhere. In fact, a lot of standards, even in electronics and networking, are royalty-free. Bluetooth, USB, some of the most successful standards in the world, there are no patent royalties associated with them. All of the money goes into the sale price of the product. So the perspective is, take a step back and realize that we're talking about a very small sub-segment of the standardization world here.
I think that's very insightful. And we can explore that more. But I think in practice, the tension still exists, right? In any FRAND negotiation, there's still people who own the patents, and there are still people who try to get a license for those patents. And then when they do negotiate under the FRAND terms that was committed to, and when that negotiation fails, what issues could arise? And can we go to that?
Sure. So there are really three sort of areas of law that get implicated when we talk about these failed negotiations. And again, we just have to keep in mind, most of these negotiations, they don't fail, right? Most of them result in parties being able to proceed and do their business. But sometimes they fail, and they can fail for two reasons. Either a patent holder is asking for too much, or the product manufacturer was willing to pay too little, right? In both of those cases, you're going to have a disagreement. And you've got three different sort of legal realms that this touches on. We've got the basic contractual question. The standards organization's policies that contain the FRAND commitment are interpreted as contracts of one kind or another, third-party beneficiary contracts, or directly binding contracts. So there's contract law and interpretation. You've got patent law, because we've got infringement issues when somebody is operating without a license, and then defenses to patent infringement. And then you've got antitrust and competition law, which we'll talk about more, I think, because there obviously is some market leverage that you get when you have patents covering a standard.
Right. So let's focus on the remedies issues a little bit. So when a negotiation fails and a patent owner is saying the other one, if you are not getting a license, you're going to infringe on my patent. And then what could be awarded as a remedy? Money and something else, right?
So the remedies will depend to some degree on which of these legal theories you're operating under. And sometimes the cases mix up and include a lot of them, right? So from a purely contractual standpoint, if an implementer, we'll use your terminology since it's
Right.
hard to get away from, but when an implementer thinks that a patent holder is not complying with his FRAND commitment, well then, the implementer can sue for breach of contract in a in any court that can hear a contract claim. And the remedies for breach of contract are several, right? There are, of course, monetary expectation damages, and there's specific performance. The specific performance remedy is one that is sometimes sought where you try to get the patent holder to grant you a license on terms that do comply with the FRAND commitment, right? And that's the end goal of all of these procedures, is to get products that are standardized out into the marketplace. The implementer wants a license, and so getting that specific performance is going to be what it needs. Now, if you move to the patent world, sometimes it's the patent owner who sues first, right? Not the implementer suing for breach of contract or failure to, negotiate and bargain in good faith, but the patent owner will sue for infringement because, of course, the implementer who doesn't have a license is possibly infringing the patent. So then you have your patent remedies, and the patent remedies include both monetary remedies and injunctive remedies in the US and in most other countries. The monetary remedies are going to be a minimum of a reasonable royalty, which can, of course, be enhanced to up to triple damages in the United States. Other countries have greater enhancements. China's recent amendments to its patent law allow fivefold increases for willful infringement. And then on the injunctive relief side, you've got injunctions that you can seek.
Yep. So let's focus on the injunction, which is the most controversial part a little bit. So in US, at least when you're seeking injunction, you usually want to prove several things. One of them is irreparable harm. And why is that a problem when it's in the FRAND context?
Right. So in the U.S., obviously under the 2006 Supreme Court eBay versus Merck exchange case, there are four equitable factors that a court will consider when deciding whether or not to issue an injunction in a patent case. And the first two eBay factors actually meld together. Most people consider them to be the same factor these days. They are whether the patent holder will be irreparably harmed if the injunction isn't issued. And what irreparable harm generally is taken to mean is the second factor, that he won't adequately be compensated by monetary damages, right? If you'll be made whole simply by money, then there's no reason to issue the injunction. And so the trick to this question comes about with the FRAND commitment, because with a FRAND commitment, when a patent holder says, I commit to grant everyone who asks for a license on FRAND terms, that's a royalty-bearing license, and obviously the patent holder is willing to accept money to compensate for the patent. So the argument goes that if you've made a FRAND commitment, you are willing to accept monetary relief. Therefore, you are not irreparably harmed if an injunction is not issued.
Yep. I think that's exactly the issue there. So let's, I think it's probably helpful to walk over maybe one or two important cases here, and maybe just so to give the audience a little flavor what is happening. So the FTC has brought cases under Section 5 of the FTC Act, and they have been influential. And there is private antitrust suit as well. So we're seeing a bunch. Can you just highlight one or two so that we know what is going on with the application of antitrust law in FRAND context here in the U.S.?
Sure. So there are lots of intersections between antitrust law and the standardization world, right? I mean, there is both, there are unilateral conduct implications and sort of coordinated conduct implications. And so, and then you've also got the FTC Act, Section 5, which polices unfair methods of competition. So three general theories of relief here under the antitrust laws. Some of the earliest cases in this area were for coordinated conduct. So back in the 80s, a couple of standards bodies got into trouble when their members tried to distort voting processes and distort the standardization process through relatively nefarious means. I'm talking about the ASME and the Allied Tube cases back in the 80s. Those led, of course, to STOs creating policies and procedures that impose some due process requirements on STOs that hopefully have kept most of them clear of those types of issues. Nevertheless, there are antitrust issues that come up regularly. And the first big batch of these cases in the 90s related to disclosure. So as you know, STOs have two types of policies that are intended to prevent patent holdup in the standards area. One are disclosure policies, where participants have to disclose their patents that potentially cover standards. And the second type of policy is a licensing policy. That's where the FRAND commitments come in. You agree to license your patents. So on the disclosure policy side, if you conceal your patents from the STO, that is potentially a bad thing. And those alleged disclosures came up in a number of cases. The FTC's Section 5 case against Dell Computer, its case against Rambus, the private litigation between Infineon and Rambus, Broadcom versus Qualcomm, all of those and more were disclosure cases. There's a Unical case, which also came up in that general realm. In all of those cases, the patent holder allegedly had patents covering a standard or was in the process of applying for patents that covered a standard and didn't disclose them to the STO. And so in Dell, a consent decree was reached with Dell in which it conceded, didn't concede guilt, but agreed that it wouldn't enforce its patents against implementers of that standard. The same result occurred in Broadcom versus Qualcomm, in which under various theories, including waiver and estoppel, Qualcomm was precluded from asserting the relevant patents. The FTC's case against Rambus resulted in a commission decision against Rambus, which was eventually reversed by the DC Circuit on antitrust grounds because of difficulties in proving an antitrust injury, which I'm happy to go into later.
Right. Sorry to interrupt you, but I think our audience has had a flavor already. I think collectively people can get that there are behavior issues, there are something about due process, there's something about disclosure. So on a very high level, do you think with all the litigations going on, government litigation, private suits all together, does that build up to the conclusion that the FRAND framework is not working well? At least it's not working sufficiently well as people would expect it. I guess that's the premise that we have for the discussion, that there would be need for a fix. Is that right? Or what do you think, if it's working well, but what are the aspects that can be improved?
Yeah, so it certainly can be improved. The fact that there are these large disagreements over the rates that are charged. And again, you can point to enormous differences from cases, the cases less than 10 years ago that started this problem, 2,000x difference between the original demand and what a court determines as FRAND, 300x difference. These are pretty big. And so there are definitely instances where there are big disagreements and there is not clarity around what these FRAND rates actually mean. Intentionally, the SDOs don't get into dictating what FRAND is defined as. And so we do have a problem of uncertainty. Mm-hmm. And uncertainty is never helpful in the market. You always have someone who can take advantage of it. Mm-hmm. Generally, that's whoever has more leverage. The threat of getting an injunction is one of those ways to apply leverage to get somebody to agree to something that they otherwise wouldn't, and to extract an excess rent from something for more than its value. Mm-hmm. So I do think there is a problem.
So one of the specific critiques that I think we've heard is that FRAND litigation, not so much with the framework, FRAND litigation is at least not so helpful in promoting competition and innovation, in the sense that it's so costly. And frankly, some argue that it should not be an antitrust issue at all, because it's contractual agreement that was once made, and then it's straight up contractual dispute. Why cannot it be analyzed just under the law of contracts instead of antitrust law?
Well, sometimes it can, if there's not an antitrust violation, right? Mm-hmm. I mean, that's kind of like saying, well, pricing agreements are just contracts, so why not just analyze them as contract law? Well, if they happen to involve price fixing or market allocation, then of course the antitrust laws are implicated. Likewise, if a contract is a contract to assassinate somebody, well, then the criminal law is implicated. I mean, you can't just say, well, let's throw out all these other areas of law if those other areas of law are violated, right? So I guess I would say if there's an antitrust violation, then of course antitrust law should be considered.
And given, I guess, all the, often these antitrust claims will come up in the context of a patent claim amongst private parties. There's increasing desire amongst federal regulators to better mediate that tension between IP and antitrust. Do you see, federal regulators or state regulators starting to push on that boundary and use antitrust law to regulate, patents, and how would you see that happening?
Right. So, the U.S. is a very interesting case because, its policy in this area is like a ping pong ball. Mm-hmm. When you get changes of administration, people in the DOJ change, and the policy sort of flips around 180 degrees, depending on political preferences for which of these sides you happen to like more. It's very unprincipled, and frankly is pretty much just straight out political favoritism of one side versus another. And they do get involved. Obviously, the Department of Justice is an enforcer, and what it decides to enforce or not will be guided by what the preferences are within the agency. I mean, the good news, I think, for the market is that these federal agencies don't make the law. Mm-hmm. They're enforcers, they're not lawmakers. And so it's the courts who make the law, and at least federal judges have life tenure. And, there is a bit more consistency and balance, I think, in the way that courts treat these questions. And so we do have that as a backstop. I would say that, the courts in the U.S. have not been especially amenable to some of the antitrust claims that have been brought in these cases. As I mentioned, the D.C. Circuit reversed the FTC's ruling in Rambus back in 2008. The Ninth Circuit reversed the Northern District of California's ruling in FTC versus Qualcomm just a couple of years ago. And so, it's very clear that the agencies aren't making the law, and the courts are. And the antitrust law in the U.S., for numerous reasons, is narrowly interpreted, very different than it is in most other countries. But it is challenging to succeed on one of these antitrust claims in the U.S., although it's certainly not impossible.
I'm going to try to be provocative just for the sake of argument. I think on a very high level, if people are saying there is a systemic failure, it's not the system, the FRAND negotiations, then which led to a lot of litigation or like very costly negotiations. If that does not work, it could be partially because the patent owners, they have just assembled these large portfolio of intellectual property assets. And then I think you recently testified in Congress that there are frankly quite too many bad inoperable patents. And then that's sort of like, partially that's the result that we're having, is that then you have these powerful patent holders in this one side of negotiation. So then you're essentially seeing antitrust law being help or rescue to the to the places where patent law is not sufficiently guarding against these bad inoperable patents. So again, I'm trying to be provocative just for the sake of argument, but how do you respond to that?
Yeah. So, I mean, there are various different problems in all of our legal systems. Patent law has its own problems. What I testified about the IP subcommittee a few weeks ago was inoperative patents, mostly in the biotech space. I mean, honestly, there are certainly plenty of invalid patents in sort of the telecom world. And patents can be invalid for a bunch of reasons. There's prior art, they're obvious, or whatnot. And there are those, right? I mean, as studies, recent study by Mark Lemley and Tim Simcoe shows, a lot of patents asserted in this area are invalid. Mm-hmm. I would distinguish. I mean, I wouldn't call them inoperative. They're, the technologies are real technologies. We're not talking about some miracle cancer cure that somebody just dreamt up and it never worked. Mm-hmm. This technology actually works, right? The technology is good technology. Not all the patents are good patents, but the large SEP holders, they've got legitimate patents, right? Even if they've over-declared how many are essential, and even if some of them are invalid, at the end of the day, there are patents. And they're valuable, and you need them, right? Mm-hmm. Some SEP holder has 500 or 1,000 patents. Even if half of them are invalid, you're still going to need to contend with the half of them that are left, and those I would consider pretty legitimate. And so I don't see antitrust stepping in to address failures in the patent system in this way. Mm-hmm. I think that sort of this combination of contract, patent, and antitrust work together to make a FRAND system that should work, where valid enforceable patents are licensed at fair and reasonable rates, and that undue pressure and abusive market position isn't used in order to elevate the rates that can be obtained.
Mm-hmm. Mm-hmm. That's very helpful. I have only one substantive question left, which is covering the last bucket that we mentioned, which is reformation and predictions. Would you give us some of your insightful predictions about international development of the FRAND world? What are some notable trends or some observations that you think we ought to be paying attention to?
Yeah, absolutely. So, I mean, in my opinion, and I've written about this a fair amount, in my opinion, the biggest issue that we've got in these types of cases is the international jurisdictional competition that's going on. Mm-hmm. You've got courts in the UK, in China, and in the US, and probably other countries soon to come online, that all of which say, we're perfectly entitled to establish the global FRAND rate for the relationship between these two global companies, right? And courts can do that because the FRAND question is a contractual question. It's not a question of assessing patent damages in countries that are outside of the court's jurisdiction. They're establishing a rate for a global contract. But in doing that, they are also establishing rates for patents outside of their national jurisdiction. And this has just so obviously created a race to the courthouse, mm-hmm.
Where entities, which courthouse, right? Like when there are multiple.
Which courthouse?
Yeah.
Right. You've got competition among the jurisdictions. So you've got two races that are both inefficient and unproductive going on here. You've got the race to the courthouse. Parties are suing each other before they should, before they have really given a chance to resolving their dispute. Why? So they can be in the jurisdiction that's going to treat them better. And then you've got a race to the bottom among the jurisdictions. Which jurisdiction can provide an answer that is more favorable to my side? And so this is just totally obvious to anybody who's watching this situation. So there's clearly forum shopping going on here. If an implementer wants to get a global rate established that's low, it's quite possibly going to go to China and seek a declaration of the global rate. If an SEP holder wants a rate that's high, it's probably going to go to the UK, which has said it's open for business for establishing global rates. And the US falls somewhere in between. We also have this wild card of jury verdicts that really freak out people and companies from outside of the US. But, they're also there in the mix.
Well, Professor, I think that's very interesting and something that certainly will be things that we will watch. And I think you've actually teed up our next episode quite well, and we'll be looking more closely at some of the international developments in FRAND litigation and tackle this forum shopping that you've discussed. So, George, before we let you go, we ask all of our guests a couple of questions so we get to know you better. The first question is to tell us something about yourself that we wouldn't know about you if we only knew you professionally.
Right. Thanks. So, and I'm going to amend my answer to that, or amend the question a little bit as I answer. So the people who know me in this context, where we're talking about standards and telecommunications and computing, they probably don't know that I also am interested in genetics and healthcare. And I actually have an adjunct appointment in our Department of Human Genetics. I teach a class in this area at the medical school here. And I've also written a book that I'll plug very briefly, which is about the myriad gene patenting case that is for a general audience. It's not for lawyers or scholars or academics. That hopefully, will help a broad audience understand things about both patent law, but also genetics and public health.
Very
Christina.
Cool. Are you a doctor, medical doctor, MD, or just a professor, JD doctor? No. Okay.
I'm not a doctor. I mean, my training is in electrical engineering, which is, of course, why I do the telecom stuff.
Yep.
I was just going to say that we should amend questions to preclude answers like that. What we don't know about you, current profession, people are just going to point to the other professional world that they work in. So plurals, and none of your professions.
And George, do you have any advice for young law school students or professionals who are looking to do what you do?
So please come do what I do because there's a huge need for it. One thing that I would say, especially for our U.S. law students, is take international law classes. This will, I guess it sounds like your next episode will be about this, but in the U.S. we are so inwardly focused that in these global industries, that is just a bad pathway. And those students and lawyers who know something about what's going on in the rest of the world are at a huge advantage, even in thinking about what policy and law should be here.
Great. So we are going to kick off our inaugural sort of final segment, what we're calling the Curious Listener.
And now it's time for The Curious Listener.
So we have solicited questions from our listenership to ask our guests, and we have one for you.
My name is Kevin Costello. I'm a first-year associate in my firm's Antitrust group, and this is my question. A lot of the action in antitrust right now seems to overlap with intellectual property and technology more broadly. For those among us who find all this stuff interesting but who lack a science background or any sort of technical expertise, what's your advice on how to get up to speed and stay in the loop on the different tech and IP developments that affect antitrust law? Thank you.
That's a really good question. And a question that my students ask all the time. I mean, the good news is that in this field, we're really talking about litigation and corporate transactions. So you do not need a science or engineering degree. You only need that if you're going to go be a patent prosecutor, which is also a great field and which I highly recommend to those who can do it. But I also recommend that you really do need to understand what the industry dynamics are in this field. And so all I would say is read the trade press, subscribe to Wired, look at Ars Technica, see what technologists are saying. You don't need, to do differential equations and Fourier transforms to understand, who are the market players in wireless telecom. Where is 6G, right? We're hearing about 5G, 6G up through 8G are already being talked about. You should know that. And you should know who the companies are that are involved in this. And it really will help show sort of where the industry is going and honestly where the new issues are going to come up.
Great. Thank you, Professor Contreras, for that answer. I'm sure our listenership very much appreciates it. And to all of our listenership, thank you for listening to this episode of Our Curious Amalgam.
Listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.